Hello there. Thank you for joining us today at the Community First Podcast, a B&P podcast that seeks to discuss legal and social issues affecting our community. Today, I have with me Audrey Nana Oye Adi and Ajua Obusuminta. They are both brilliant lawyers who work with us at the firm, and they are both part of the business support services. Ladies, you are welcome to today's episode.
Thank you very much, Olga.
So if you're just like me, you be passionate about corporate governance matters. So anything corporate governance counts as in, I guess, right? Yes. And so today we would be discussing matters regarding the rights and then the powers of board and shareholders specifically. But I mean, we would touch on matters that affect, the operation of companies. Who has the right to take certain decisions, and to what extent can they implement that decision, right? So today, before we go into the discussion, you will all agree with me that a company is a juristic entity that takes certain decisions, right? It can be sued, it can sue, it can purchase property, etc. Now, you would think that these decisions are taken by a certain group of people. Okay. And once you are entering into a contract with these people, you say that this contract has been sealed. It would come to bear that sometimes there are certain approvals that the company did not acquire before undertaking this decision. So it brings me to this question. Ajua, what then is constituted as a decision of the company, or what constitutes an act of a company?
Okay, so as you stated, a company is a juristic person. Another way of saying it is that a company is an artificial person. Because it's an artificial person, just like a vehicle. I mean, it doesn't have hands, it doesn't have legs, it doesn't have the ability to think on its own. So therefore, it requires certain people to perform certain acts on its behalf in order to keep it running. Mm-hmm. So an act of a company will be defined by the Companies Act as acts performed by the members of a company in a general meeting, the acts of a board of directors, or the managing partner, which is within the usual course of business of a company. And these acts will create a civil or criminal liability for the company as though a natural person committed those acts. So those are generally the acts of a company.
Right. Yeah. So from what you said, I noted directors and shareholders. Apart from these, are there any other organs or any other persons that are considered as members who can take decisions for companies?
So every company has an organogram. Okay, yeah. It's a whole. How do I say it's a hierarchical order. So I look at it as a diagram. There's the shareholders up there. There's a board of directors. There's the management, the officers of a company. There's a company secretary. There's an auditor. Generally, the officers of the company are also part of the company. Okay, their acts. The acts of the board of directors, the shareholders, the managing directors are primarily known as the acts of a company because automatically these acts are considered as the acts of a company. However, for the officers and the agents of a company, ordinarily their acts are not considered as acts of a company unless they have the express or implied authority of the board of directors or the members in the general meeting to perform those acts, or their acts are ratified eventually after they've performed them, or the company has made certain representations that show that these acts were performed by them, and then a third party relied on these representations that were made by the company. Then those acts will be considered as the acts of a company.
Right.
Yeah.
So, I mean, for the purposes of today's conversation, we are looking at the powers between the directors and then the shareholders. So I would limit our conversations to these two entities, okay, or these two parties. Now, can you walk us through or just give us a summary of what each, the powers between the directors and shareholders, to what extent can they act? So just a summary of who a director is and what they can do, as well as that of a shareholder.
Okay, so I'll start with the shareholders. So the shareholders are considered as members of the company. They are owners of the company. They have ownership rights in the company. So as the name goes, shareholders, they own shares in the company. So they are expecting a return on whatever investments that they have in the company. Based on their roles as shareholders, they enjoy certain rights. And a member of the company is a person whose name has been entered into the register of the members of the company as a member of the company. So a shareholder has rights, like all shareholders have rights to attend general meetings. They have rights to vote. They have rights to enjoy dividends. They have several rights that are attached to them as just by virtue of the fact that they are shareholders of the company. Directors, on the other hand, are the fulcrum of the company. They are the mind of the company. They are the nerves of the company. If the company was a human body, the directors would be considered as the mind and the nerves of the company, because they steer the affairs, or they manage and administer the affairs of the company. So they come up with the strategies, and then the management and the officers will implement those strategies to ensure that the company is steered in the right direction. So majority of the corporate powers of a company reside in its directors.
Right.
So unless expressly stated by the constitution of the company or by the Companies Act that certain managerial roles or certain administrative roles are reserved for the shareholders, then the directors have the power to act within. The directors have the power to perform those roles. They have the power to do those things. Yeah.
Okay, so I know some of the transactions, or I know some of the resolutions that require shareholders' approval would include change of name, change in constitution, the business, the objects of the business, and major transactions. Okay, and this is a very important area, the major transaction, because it affects, significant parts of the business. So I would like our listeners to have an idea of what a business transaction is. Audrey, I have packaged this question for you. Would you kindly let us know what a major transaction is?
Okay, so a major transaction is a transaction of such significance that the law generally requires that shareholders approve that, rather than leaving the decision solely to the directors, because the nature of the transactions are such that it can fundamentally affect the company's assets, their business position or financial position. So at the end of the day, because the shareholders own the company, they should have a say in that. And because it can also significantly alter the shareholders' investments, the law requires that such transactions should be approved by the shareholders. And under the Companies Act, a transaction is a major transaction if it involves more than 75% of the assets, of the value of the assets of the company. So whether you are acquiring or disposing of assets of the company, the value of which is more than 75% of the assets of the company, or if you're acquiring liabilities, the value of which is 75% of the assets of the company, then that's a major transaction. In that case, you would require a shareholder's approval in that regard. But there's some form of exception that applies if the company enters into an agreement to give a charge secured over the assets of the company, the value of which is more than 75% of the assets of the company, for the purposes of repaying a loan or performing some specific transactions. But generally, if the transaction that the company is entering into affects more than 75%, as I earlier explained, then it's a major transaction, and then you need shareholders approval. And under the Act, the shareholders approval that's required is a special resolution.
Right.
And special resolution means you need the votes of more than 75% of the votes of the members of the company. So it's not just about getting shareholder approval, but getting a greater majority of shareholder approval because of the nature of the transaction and its impact it has on the investment of the shareholders. So let's say, for example, a logistics company owns a warehouse which is valued at about 160 million. They have machinery valued at about, say, 40 million. And they have trucks valued at about 10 million. If the board proposes to dispose of the warehouse, which is 160 million, then in that case, the board would require a shareholder's approval, a special resolution by the shareholders, because that disposal of that asset constitutes a major transaction because of the value in relation to the entire assets of the company. So the key takeaway here is that if the transaction is likely, the higher the impact of the transaction on the company's financial position, the more likely it is that it is a major transaction. In that case, you would require a special resolution by the shareholders before you can proceed with such a transaction. So basically, that's what shareholders, a major transaction is basically about.
Right. So I know you mentioned an exception where the board would not require the shareholders' approval before they enter into a major transaction. Apart from that, are there any other exceptions that you know of?
So basically, because the law has established the threshold of what constitutes a major transaction. So if an intended transaction falls within that scope, then you need to get the requisite shareholders' approval. Of course, there are some situations where then because of the timelines and then the urgency of the situations, it may be a bit difficult to convene shareholders and then get them to agree. But in such a circumstance, it will be very, very advisable for the board to leverage the mechanisms that have been provided within the Act and the company's constitution to get the shareholders together and then ensure that then the right thing is done. So you can take advantage of one of these provisions. You can take advantage of the shorter meeting time provisions provided within the Companies Act, or that can be provided within your constitution. So for example, generally for general meetings of shareholders, you need at least 21 days notice period for convening a meeting. But in some appropriate circumstances, if the right thing is done, you can the timeline for the notice period can be shortened. So for AGMs, for example, if all shareholders consent to shorter notice, you do not need to convene the meeting within the 21 days notice period if all shareholders agree. For an extraordinary general meeting, for example, if you are able to get at least 95% of shareholders consenting to shorter notice, then you can go on and then hold the meeting without meeting the 21 days notice period. This is just one example. Another example or approach that can be explored is getting shareholders to execute a written resolution instead of convening a meeting. But it's important to understand that not all decisions can be taken via a written resolution, provided that the decision to be taken is within the scope or it's legally feasible for you to do that within a written resolution. For example, the removal of a director or the removal of an auditor cannot be done by a written resolution. It necessarily has to be done by a general meeting. So these are some of the things. In commercial transactions where time is of the essence, a common approach that you can adopt is to negotiate and sign the agreement subject to a condition precedent requiring shareholders' approval before completion. These are some of the safeguards that ensures that you're preserving the deal, but also ensuring that you're acting within the confines of the law. So these are some of the things you can practically take into consideration to ensure that you obtain a necessary shareholder approval when time is of the essence and things need to be done quickly.
Right. So whilst you were speaking, I was just reflecting. I've seen we've been on board meetings for some years now, and we've seen some board members who are very passionate about certain transactions. They want to get the work done. But their shareholders, sometimes, they are either hard to reach or they are not really interested in that transaction. However, the directors think that this is in the best interest of the company, right? In a case like this, okay, the directors sometimes, if sometimes they overlook the approval process and say, hey, we'll just pass this resolution and get the work done anyway. Are there any consequences they would bear? And if so, what are they?
Okay, so there definitely be some consequences that will come up as a result of such actions. First to the company and as well to the director, because if you enter into a transaction and do not have the requisite authority, the transaction may eventually be invalid. As a director as well, you may be exposed to personal liability for breach of your duties, because bear in mind that directors stand in a fiduciary relationship with the company. They are supposed to exercise their duties within the limits and the powers set in the Companies Act, in the company's constitution or other foundational documents.
Right.
And they must exercise their powers with care, reasonable care, skill, and diligence. So if you you act outside your powers, and then at the end of the day, there are some losses or damages that a third party gets into, or even the company gets as a result of your action, then as a director, you will be personally liable in your personal capacity to compensate the company, compensate any third party for your actions that led to those consequences. And the board as a unit as well can be jointly and severally liable for their actions that caused those consequences to the company or even the third party.
Okay. So, I mean, there sometimes some directors have a different opinion. They do not really agree with what the whole is trying to resolve at. Based on what you just said, would this director also, who has a different take on the whole board's decision, would that particular director be affected, or is he also personally liable for any damages, any damage or injury the company may suffer because they have decided to take a decision that is not in compliance with statutory approval levels?
Okay, so say that as a director, you have to act in the best interest of the company. You also have to exercise independent judgment.
Right.
And that is where the importance of good record keeping comes in. So if deliberations are being had at a meeting, you have strong opinions about it, you are opposed to such a decision being taken by the majority, it's important that you have your views accurately recorded within the minutes, because at the end of the day, the records will show that when this decision was being taken, Mrs. A stood against it, verbally expressed her opinion, encouraged the board to look at it in a different light, but that was not considered. So it's important to ensure that minutes are well taken to record any objections, so that at the end of the day, if there are any issues that arise, if there are any liabilities that come up, there's evidence to prove that you objected to it. There's evidence to prove that you spoke against it. You were not aligned with what the majority were thinking at that point in time. And in that way, it helps a bit, because there's some documents to prove. At the end of the day, minutes are a matter of record, and then there's something to prove that you acted diligently, you exercised reasonable judgment when deliberations were ongoing before the decision was eventually taken by the majority. So when any liabilities come up at a later point, there's something to lean on, in a way, if I can put it that way.
Yeah. I think from what you just said, it is best to say that it is very important for companies to have company secretaries who are able to record minutes and record them properly, because this secures you and your future, just in case your minutes end up in courts. So that's a very good take, Audrey. So I was thinking, if it turns out that a transaction was not properly received by shareholders and it's nullified, what happens to the third party? Do they have some sort of remedies for the third party, or you just carry your losses and off you go?
So as I stated earlier, the acts of a company are acts performed by the members of a company in a general meeting or by the board of directors or a managing director, acting in the usual business of the company. And the company is civilly or criminally liable for these acts performed by these people. So there's always always likely to be a criminal or a civil liability as a result of these acts of the company performed by these members, because the company will be treated like the way a natural person will be treated if they enter into a contract. And there's a presumption of regularity. That presumption states that anybody can rightly presume that a company has been properly incorporated. The members have the power to enter into whatever transaction and all that. So once these acts are performed by the board of directors, and later on it comes out that the shareholders don't agree to it, based on this presumption, I as a third party should have some remedies available to me, because I presumed I was working on the board of directors. On their company profile, I knew that these were the board of directors. It didn't behove on me to go and find out if they were acting necessarily within their powers or not, unless I had actual knowledge or based on my relationship with or my position in the company, I ought to have known that these people did not have the authority. Then, because I have actual knowledge, and I wouldn't be afforded these remedies. But once I did not have actual knowledge, then there should be some remedies available to me. So I may be entitled to damages, specific performance. I can bring an action against the company. Yeah. So this is just to protect the third party who enters into transactions without necessarily having to put the extreme burden of conducting extreme due diligence on them. Because if a company represents themselves as, or represents certain people as the people working on their behalf, then I can safely assume that I was working with the right people. So if the contract cast has the
Gentility.
yes, I should be afforded. I should be afforded certain remedies. So the company, the shareholders can maybe do a cost-benefit analysis and decide that, okay, even though, despite the fact that the board of directors hurriedly went ahead with this transaction, even though it's a major transaction, they required my approval, I'm going to go ahead and do what? Ratify the transaction, and that is fine. So it's either ratify the transaction or see in court, something like that. Remedies available.
Right.
Yeah.
Right. So, I have so many more questions, but we are pressed for time. So I'll throw in my last question and let you off the hook. I'll start with Audrey. Audrey, per your experience as a corporate commercial lawyer, you handle other aspects, but in regards to corporate commercial law, and as a company secretary representative, right, on so many boards, what are the common pitfalls in terms of the struggle? The power struggle between board and shareholders, and what advice would you give to board members in this regard?
Okay, I'd say that more often than not, the issues that frequently arise tend to be more about governance discipline.
Yeah.
Because people do not fully appreciate where the powers of each organ begin and where they end. The managing director should know when a matter should be sent to the board, and the board should equally know when a matter should be sent to the shareholders. Issues would arise when people extend beyond their powers and perform the powers that have been conferred on another organ, and then that is when friction starts. As between board powers and shareholder authority, I'd say a common or a key concern will be treating commercial agency as a substitute for authority. Yes, we understand that sometimes commercial transactions will arise with tight deadlines, but the mistake is assuming that if we do not sign today, we'll lose this deal. While that may be commercially true, it doesn't take away the fact that you need to also get the requisite approvals, the necessary consents to ensure that the transaction can go on smoothly, to ensure that you do not get there will be no liabilities at a later date. And that is very, very important, because you should know your shareholder. Not every shareholder will be willing to ratify an unauthorized decision in the first place. And even if ratification is available, it doesn't change the fact that you acted outside your powers. You acted in breach of your fiduciary duty. You acted outside the powers that had been conferred upon you. So it's always important to do that balancing act. Ultimately, I believe that good corporate governance is about respecting the responsibilities and then the authorities that have been conferred on each organ of the company, if I can put it that way. Because if everyone acts within their powers, if everyone respects the authority and then the powers and the limits of each organ, we are able to run together as a unit, because at the end of the day, our goal is to ensure that the company progresses. The shareholder wants his money, return on his investments. Directors wants the company to improve.
Yeah.
Management of the company, we're all working towards the same goal. So if we're all able to respect each other's powers and act within that, work collaboratively, I think at the end of the day, it's going to inure to the benefit of the company and all stakeholders involved, and will actually help to reduce the friction that we often see between the board, between the management, between shareholders. Yes, so I think that's what I would say.
That's very profound, Audrey. Ajua,
I said everything.
you said everything.
Yeah. Yes, I don't want to rehash what Audrey said, but good corporate governance recognizes the fact that there are competing interests by different stakeholders, and you'll be amazed at the number of stakeholders that of a company, basically. We also, what happened when some banks collapsed, right? There was a ripple effect to the consumer, somebody staying at home, the government, there was so much that's happened. And this is what happens when corporate governance fails. And this is also because we live in a fast-paced environment. So yes, sometimes like, we are in a hurry. We don't, I mean, basically the strategy is brought by the directors. So they sometimes feel like, okay, they know what is best for the company and they're acting in the best of interest. Because of course, if the shareholders, they don't have any trust in the directors, they wouldn't have appointed them in the first place. However, it might be interesting to note that in the previous Companies Act, there was no provision like the shareholders being required to approve major transactions. But if you think about it, if I've invested my money into something and somebody is going to conduct a business or a transaction that's this huge, so it's the extent of taking about 75% of my assets, then I as a shareholder should have a stake. So I think that's the logic behind it, because if the director goes ahead and they do it, the shareholders don't have any idea, they are not given the same, then the company ends up going bankrupt or collapsing. The effect is not just on the directors. Okay, they might have certain liabilities, but it's going to affect the shareholders. It's going to affect creditors. It's going to affect consumers. It's going to affect the government. So there's a ripple effect. So as Audrey said, you just have to make sure that you find the balance. It's not always about I don't have time to go and seek shareholders' approval. As she said, major transactions are some of the transactions that you do not need, a board, like an annual, general meeting for, because a written resolution would suffice. So I think that the board should always ensure that they act within their ambits, and then the shareholders must also ensure that they do not try to influence the board to do their bidding all the time. Yeah, so that's basically what I have to add. So,
thank you so much, ladies. Today's discussion has been very successful. Before I say bye-bye to our lovely audience, do you have anything else you'd want to say regarding the topic?
I think we should keep the conversation going, because corporate governance is very crucial in today's world, and maintaining the right systems, doing the right thing, it may seem abstract, but that's what keeps the company running. These practices or these rules or these principles that have been put in place in the Act, in the Constitution, is just to keep the company as a unit or as a body running effectively. So let's keep the conversation going. Keep on talking about corporate governance, the right practices that companies must put in place, and make the world safer.
Thank you so much, ladies. All too soon, the conversation has to come to an end. As my lovely guests have already mentioned, it's important that companies prioritize corporate governance, good corporate governance, and stick to what the directors, especially, you have to stick to what you are supposed to do within the range of your powers. And shareholders as well, you also need to ensure that you trust your directors to do the job. Hence, there's good collaboration, and then the work would be done. Your companies would be successful. Thank you so much for joining us today. And if you have not liked our discussion yet, please do like and then follow us or subscribe by clicking on the subscribe button. Thank you so much once again, and enjoy the rest of your week.